Hi, I'm Dave Racer. This talk is being put together about a week before the March for Life in 2023. That, of course, is the celebration or remembrance, if you will, of the infamous Roe v. Wade decision that legalized abortion in the United States and interfered with the various states that were in the process of debating abortion at the time. This talk emanated from my study of the decision of Dobbs v. Jackson Health Systems, which you'll find out in a minute exactly what the Supreme Court reasoned in that decision and how they came to overturn Roe v. Wade and the Casey decision. This talk is going out to my good friends at First Evangelical Free Church of Maplewood and to you. And I thank the people at First Free for encouraging me to do this talk at this particular time, a very critical time. So because of that, if you're not from Minnesota, this will apply to you across the board. But I'm going to be making some references in this talk to things that are going on here in our legislature that may not be going on in your legislature. Or they may be going on in different ways, or they've already happened. The important thing here, I think, is that we get our arms around what Dobbs v. Jackson meant, how the court interpreted it, and then how it's being applied and can be applied, what the potential is, and whether or not our celebration at the decision was warranted, or has it created something new for us about which we need to be concerned? So let's get going and let's delve into this remarkable, momentous decision. I've titled this talk, Dobbs versus Roe, What's Next for the Preborn? Many of you do not know me, even folks from my own church don't know some of my background, and I just want to go through this quickly. You might say, what gives me the credential to even give a talk like this? And I could say I stayed at a Holiday Inn Express last night, but I think probably I've done enough other things that you'll see why at least some people feel I'm qualified to do this talk. I am a teacher, writer, author, and speaker. I am a board member of the Human Life Alliance. I was the national campaign manager for Alan Keyes for president in 1996, the first Black Republican to run for president and known everywhere for his pro-life views. I myself have been an endorsed candidate for office, a campaign consultant, and as it regards this talk, a former chair and president of the Constitution Educational Foundation and the founding president of the Declaration Foundation. I also have taught American government for 24 years at an academy for homeschool students and have just created a brand new course on the U.S. Constitution. Maybe someday you'll want to see that too. I have been married for more than 55 years. I'm the father of 5 and the grandfather of 10. So let's move on a little bit into our study. Here, legislatures, when they convene, you can often tell what their priorities are by the first bills that they introduce each session. And it's quite remarkable in Minnesota. And by the way, maybe just for contrast, 20 years ago in the Minnesota legislature, House File 1, the first bill introduced in the legislature, was about anti-terrorism and having to do with driver's licenses and that sort of thing. It's not surprising because we had just gone through the attacks of 2001. That was still on people's mind. And the Senate File 1 in that year was the Wellstone commemoration, commemorating Paul Wellstone and his wife. Well, what about this year? What are the highest priorities of our new legislature? And just so you know, our House is controlled by the Democratic Farmer Labor Party in Minnesota, just by a 6-vote margin. I believe I have that right. And our Senate is controlled by the DFL, by the Democratic Farmer Labor Majority Party. and it's only a 1-vote margin. It's 34 to 33. Oftentimes, when a legislature is controlled by a single party, they rush to pass things that they're afraid they couldn't pass if the other party had control of one or the other house or both houses. And of course, in Minnesota, we have also a Democratic Farmer Labor Party governor who said that he would sign bills dealing with abortion passed by his legislature. So the very first bill introduced in the House and the Senate in Minnesota is called Protect Reproductive Options Act. In the Minnesota State House, the Minnesota State Senate, House File 1 and Senate File 1, the very first bills. This is an indicator of the priority that the Democratic Farmer Labor Party majority has given to the issue of abortion and their desire to protect abortion rights as its #1 priority in the state. This is from the bill itself. The bill and the bills are similar. There's one big difference, and I think you're going to find it fascinating. Reproductive health. It defines reproductive health, and the definition of reproductive health in the bill very specifically includes abortion. Secondly, it guarantees reproductive freedom. Reproductive freedom is the right to choose what you want to do with your reproductive health, and it calls it a fundamental right. Now, that isn't necessarily ensconced in our Constitution, but it would be the statute that would guide decisions related to reproductive health as defined in the bill. I don't want to get real granular here, but I want you to see this. House File 1, the House version of the same bill, has the same title. It has the same language as Senate File 1, except for this one paragraph. This is a very, very important paragraph. I don't know if it'll end up in the final bill. We shall see. It says individuals, and that's the word it uses, individuals, which bestows on the people defined in the bill something called human life, recognizing that each person defined in the bill is a human being. And it goes on to say individuals who become pregnant. Notice that it does not say women who become pregnant. This is a more woke term, if you will, not delineating between the two sexes, male and female, but individuals who become pregnant will have a right to continue the pregnancy or obtain an abortion. This is what the two bills are promoting here in Minnesota. If House File 1 prevails, this means, and Senate File 1 also, but even more so with House File 1, that an individual will have, as it says in the bill, the right to make autonomous decisions about how to exercise this fundamental right. This has no limits on abortion. No limits. It places the right to exercise the decision to have an abortion or not have an abortion, to carry a baby to delivery or not, to the individual who becomes pregnant. Now, that's a way to kind of set up our talk. I do want to show you a little bit of a contrast. The Congress, the House of Representatives in the Congress, as you know, is barely a Republican majority, and in the Senate, it is barely a Senate majority, Democrat majority, excuse me. And so you have split government at the U.S. Congress. But the Republicans did introduce what they call House Concurrent Resolution 3. It was introduced on January 9th, and it passed 212 to 209. Now, number 1 and number 2 had to do with business of the House. And the first one, for instance, said set the rules, and the second one notified the Senate that they were in business. So this is really the same thing as a House File 1, if you will, only it's a resolution. It wasn't a bill. I'm getting too technical, but I want you to see this again. It passed 212 to 209 by a partisan vote. 212 Republicans, 209 Democrats voted against it. And this was the key paragraph. It recognizes the sanctity of life and the important role pro-life facilities, groups, and churches play, I think it is churches, play in supporting pregnant women, infants, and families. Now, that's not a protection, or ridding us of abortion. That isn't what the bill is about. It's protecting property and people who support a pro-life cause from being vandalized and so forth. But it is, I think, an indication of a different mindset, if you will. This is not about potential life. We're not having a discussion about this idea of potential life here. What we're having is a discussion about life with potential. And if you think about that very profound statement, and that's credit to a book called Let Us Be Born by Mary Joyce and her husband. I'm sorry, I forgot his last name. I edited and published that book just a couple years ago, Let Us Be Born. And they coined this idea that this is a discussion about life with potential. Don't ever let anybody tell you that the unborn child is potential life. It is biologically, anatomically, and morally untrue. So remember, let's get into our Dobbs discussion now. Remember the leak. There was so much about the decision. When I read the leaked version, I said, oh my goodness, I can teach a whole course on the Constitution just from this decision and how the Supreme Court is supposed to work. Because with the Supreme Court, they choose, I think it takes 4 justices to agree to accept a case. And when they accept a case and they have hearings on it, someone will write an opinion, and that'll be circulated and everybody will comment on it. Well, someone leaked that first draft. And of course, it caused all kinds of manner of consternation. And we don't know yet who did that. That violated a trust among the justices themselves, so that perhaps it reduced their trust of each other while they try to have frank and open discussions, even when they disagree so much. So that alone did harm to our judicial process. So the drafts are passed around and everybody takes a look at them, and they have to have a measure of confidentiality. But eventually they did decide, and on June 24th, 2022, on the most important point in the leaked version, they overturned Roe, and they overturned Roe v. Wade, and they overturned the Casey decision. Those were the 2 decisions, 1973 and 19 years later, that had solidified, if you will, the so-called right to abortion as a constitutional provision, a federal constitutional provision that would prevail across all states. Well, overturning Roe v. Wade and Casey in the Dobbs decision immediately had an effect on our politics. You couldn't help but pay attention to the fall campaigns when it was expected that Republicans would take a large majority in the House and probably 4 to 5 seat majority in the Senate, and that didn't happen. Instead, forces who support abortion on demand used the Dobbs decision to scare people that they were going to lose their liberty and their right to health care. That was the primary message. And the message at expenditures in excess of $400 million had, I believe, a profound effect on the election. Others might disagree with me, saying Republicans ran bad candidates or they ran bad campaigns. It could be all of that, but it certainly had a huge role in the elections. And the thing is that it changed the discussion to say that protecting human life is an extremist position. If you in your state, if you weren't in Minnesota, I don't know what your ad said, but one of my former students was running for attorney general here. And I know Jim Schultz well. He's a great man, a wonderful friend of mine. And they kept running these ads against him that he was an extremist. He was an extremist because he supported the right to life. And by the way, at one time served on the Human Life Alliance board. And so they made pro-life, protecting the life of the unborn, the extreme position, and taking the life of the baby up to the moment of birth and beyond, by the way, an accepted normal position. If that tweaks some verses in your mind, if they come to mind, you'll understand. But remember this, and this is the way our Constitution works. That's why I was so excited about the decision itself as a teaching tool. 2016 is what made this whole thing possible. Many, many years of fighting among pro-life and pro-abortion advocates, very divisive issue. But it required something that only an election could fill. So you could say that babies were on the ballot in 2016, and we had a choice between Hillary Clinton, who was on record as supporting this so-called women's constitutional right to abortion, and Donald Trump, who by then had said that he was pro-life and that, in fact, he would appoint pro-life judges to the Supreme Court. And you know how that election went. And the fact is that 3 new justices were approved by the Senate, which was under Mitch McConnell's control. What I'm telling you is not to build up the Republican Party or Donald Trump or anything else. It's simply to tell you that it required an election with a major shift, a major change on the Supreme Court. So when the Dobbs when the Dobbs case was heard, it was heard by 3, well, actually 5, and maybe even 6, actually, I guess I would say 6 justices who were open to its arguments. Justice Roberts doesn't like overturning precedents. So if depending on who you are, you'll hear that it was a 6-3 decision, which would include Roberts, or a 5-4 decision, which would not. It's really somewhat irrelevant in that it was decided, and Gorsuch, I always forget the names, Kavanaugh, yeah, and Barrett were the deciding votes, all appointed by Donald Trump. Elections matter. Let's take a moment just to look at the actual law that was being debated. It was called the Gestational Age Act. It was passed in 2019 in Mississippi, and that's the citation. And I won't read the words, but essentially you can read the last sentence: to restrict the practice of non-therapeutic or elective abortion. So notice it's specific, non-therapeutic. So therapeutic abortion would not be disallowed, but elective abortion, non-therapeutic or elective abortion, to the period up to the 15th week of gestation. And it went on to say, except in a medical emergency or in the case of a severe fetal abnormality. So look at the exceptions: medical emergency, fetal abnormality. A person shall not intentionally or knowingly perform or induce an abortion of an unborn human being, not an individual. They call them human beings. If the probable, I think it's supposed to be probable, I typed it wrong, gestational age of the unborn human being has been determined to be greater than 15 weeks. It's remarkable that the Jackson Women's Health Center, which was the plaintiff in the case, did not do abortions beyond the 16th week. Just think about that. So they were suing, I guess, to gain, well, more weeks. Note, it bans abortion except in certain circumstances and up to when a state says it's allowable. It does not outlaw care. This is what the pro-abortion people have been saying, that it outlaws care for miscarriages and for ectopic pregnancies. That is an untruth. It has nothing to do with them. They are allowed. A medical emergency, certainly an ectopic pregnancy would fit into that category. And note, as a result, this was a result of a political process where the Mississippi legislature, duly elected by the citizens in their republic, were empowered or felt empowered and had hearings and discussed and debated openly and persuaded each other based on deeply held beliefs or a political strategy. And actually, if we were having a politics class here, I'd go into that a little bit, but I'm not. Okay. Thomas Dobbs, who was the defendant in the case, was the head of the state health office in Mississippi. He's a physician. He's board certified. He's been a district health officer and a state epidemiologist and an associate professor. And I'm just running through his credentials quickly because this is the key thing. He didn't go looking for the fight. He has to, by his position, working for the state of Mississippi, the responsibility to defend this decision and explain it. Okay. So that's the Dobbs. Here's the Jackson side. This is a picture of the Jackson Women's Health Center, and this came right from their website. I don't know what it says today. This is when I downloaded it. The Jackson Women's Health Organization offers affordable abortion care to women. It's interesting, to women living in Mississippi and or traveling to the state of Mississippi. So they were an abortion service provider, if you will. They did, I'm trying to think of the term now. It's what's happening in several states, people coming to their state to get abortions. And it went on to say, and this is kind of fun, we are the only abortion clinic, that was their words, in the state of Mississippi. Now, since Dobbs v. Jackson, I could change that to say they were the only abortion clinic in the state of Mississippi because they closed July 7th, 2022. If you're pro-life, you might be clapping right now. Now let's cut to the chase. Let's look at the findings itself, expressed on page 1. I'm going to show you the most critical part of this, that the Constitution does not confer a right to abortion. Wow. I helped publish a book called A Treatise on Human Life that showed that Roe v. Wade was improperly decided from a number of standpoints that tracked the right to life back to the 5th and 4th century in British common law. It's quite amazing. Abortion was always considered a homicide after quickening, and there were other restrictions on it, and there were penalties on the providers and penalties on the moms, frankly. So the Constitution, they said, does not confer a right to abortion. Roe and Casey are overruled. So that is ruling out, ruling over precedent, overruling a precedent, and the authority to regulate abortion is returned to the people. So suddenly we're back to the 10th and the 9th Amendments in the Bill of Rights, which restricted rights to, or returned rights back to the states and the people. And it goes on to say that the authority to regulate is returned to the people and their elected representatives. That is very important to pay attention to. We'll explain that in a minute. Here is the astonishing, if you will, reference to abortion and the Constitution. Let that sink in. After the death of more than 60 million babies in America, under which Roe v. Wade and Casey asserted that there was a constitutional right to abortion, this Supreme Court said, as plainly as you can, the Constitution makes no reference to abortion. So no such right is protected by any provision of the Constitution, including the due process argument that the pro-abortion movement was using today. So now at the end of the decision, I'm not going to go through the whole thing. You would just probably wither on the vine pretty quickly. I love it, by the way, and you might want to download a copy. It's quite remarkable. We end this opinion where we began. Abortion presents a profound moral question. I mean, we cannot argue with that. And it goes on to say the Constitution does not prohibit the states, the citizens, this is really important, does not prohibit the citizens of each state from regulating or prohibiting abortion. So what does that mean? Roe and Casey arrogated that authority. If you are an older American, as I am an elder now. I'm in elderhood. I do remember while I was a high school student, the debates in the 1960s in Minnesota and across the country about the right to abortion. In several states, or some states, had made legal abortion available. In Minnesota, they were debating it at the time. The Republican Party was dominated by individuals who were fiscal conservatives, but they did believe, many of them, in the right to abortion. And the DFL, the Democrats, were dominated by people who held life very sacred, might I say. Many Roman Catholics were part of their coalition. The Roe v. Wade decision kind of turned that around. And so the pro-life people came into the Republican Party, and the Democrats got the pro-abortion people. That's pretty much where it shakes out today. Anyway, Roe and Casey took away that ability that, like Mississippi had, to have their debates, and made it a federal thing. And so it arrogated the authority for the states to do that. So now they overrule those decisions. They return that authority to the people. Now look at this, and their elected representatives. We have to deal with that. So it's time to heed the Constitution, return the issue of abortion to the people's elected representatives. The permissibility of abortion and the limitations upon it are to resolve, like most important questions in our democracy. And I put that SIC there because, folks, we don't have a democracy, we have a republic, but that's for another lesson. But look at what I highlighted. The discussion is to be by citizens trying to persuade one another and then voting. Now there, you got to ask yourself whether you want to be involved in persuading one another and whether you want to be involved in voting based on this particular issue. That's what the Constitution and the law demand. So think of the SCOTUS as Supreme Court of the United States, if you're not sure, as an unelected legislature. I'm not going to get, as I said, into my lectures on the Constitution, constitutional law, and the Supreme Court. But over many years, the Supreme Court and Minnesota courts have got to the point where they start legislating from the bench instead of turning political things back to the legislatures. And SCOTUS had been doing that. And so this court ruled there's no constitutional basis for Roe. That's a really critical comment, considering how the court had functioned, because the court had gone beyond the Constitution so many times in so many ways that it had got to the point where Congress could pass whatever they wish, and the court would decide whether it was constitutional. Well, and there was no common law basis for abortion. We already discussed that. Also, it's based on a principle called enumerated powers. And I have to say there's great ignorance about this, that the federal Constitution is a document, the first 7 articles of enumerated powers. They are the powers that we, the people, granted to the federal government. There is no power in those 7 articles for the federal government to be involved with abortion. Just doesn't exist. Except as the court has continually said otherwise. Now I have to say those enumerated powers are to limit the reach of the federal government, and the federal Supreme Court has gone beyond that and legislated from the bench and given the ability to legislate way beyond constitutional enumerated powers. The Bill of Rights is about the rights that we specifically wanted to make sure the federal government was aware of, that they couldn't mess with, if you will. it has nothing to do with the rights that government gives us. It has nothing to do with our permission to act in this way or that way as citizens. That again is another lecture. It's totally the other way around. So with SCOTUS acting as an unelected legislature, Constitution was silent on abortion, but the culture wasn't. And so SCOTUS acted as a legislative body, and Justice Byron White called it an exercise of raw judicial power. Again, could go into the whole history and the times around the writing of the Constitution. There's many, many things the Constitution is silent about. That's why it's a document of enumerated powers, and the federal government is not supposed to go beyond it. One of the things it's silent about is abortion. And that does not mean that it approves abortion. It's actually just the opposite. Go look at the culture of the day, look at the common law, look at the traditions, look at the people who define the terms in the Constitution, and you'll find out real quickly that abortion was not considered acceptable at the time of the founding. So there were three rulings in this decision. First of all, that state elected officials may, that means they're able to, doesn't mean they must, regulate abortions for their own state. That would be disregarding what Wisconsin does or Iowa does or North Dakota or South Dakota or Texas or anybody else. Minnesota, for instance, can regulate their own. That means the people's elected representatives. And here's where we come into a bit of a sweat, because the people who are in the Congress are also our elected representatives. And they may interpret Dobbs to mean that they have the right to pass abortion legislation. Certainly, that's the belief of one side in Congress. So it says that in this particular case, that Mississippi had the right to regulate abortion, and that meant banning it after 15 weeks, and that they could act in protecting the life of the unborn. Again, this term unborn is used in the decision to very specifically say that what is in the mother's womb is life with potential, that it is life, that this is a human life in the mother's womb. Roe v. Wade and Planned Parenthood versus Casey were overturned because they arrogated the right of states to regulate abortion. When Casey came along and the decision was decided, there was an interesting belief by the court. Casey came along 19 years after Roe, by the way, and it used Roe as a precedent to make its own decisions. It modified the decision a bit. I'm not going into those specifics, but it did suggest that Casey, its controlling ruling, would allow Americans to end the dispute and accept whatever the Supreme Court said as final. Well, you know that never happened, and abortion has dominated our politics for decades, ever since Roe. Well, before Roe, actually, 10, 15 years before Roe, it was already dominating. What the abortion did not do or establish, and I think it's very, very important that you understand this, it did not base the decision, their decision, on something other than politics, something that's above politics. For instance, in the Declaration of Independence, where it says we hold these truths to be self-evident truths, that all men are created equal. All men, meaning humans, are created equal, created, not out of some exceptional event in the creation process, but, well, the exceptional event being God created, endowed by their creator with certain unalienable rights. In other words, that rights come from the creator, not from government, and that among these are life, liberty, and the pursuit of happiness. So unalienable rights, the founders argued, have their root in creation, not in a constitution. And that points toward this idea that we have, that in the beginning God created the rights with which we are endowed as unalienable rights. That was the belief and the understanding at the founding. It's why, one of the reasons why we fought a war against England. And constitutions cannot grant rights technically. I mean, they do grant rights if they're not based on this concept that rights come from God, and then the Constitution can't take them away. That's the nature of unalienable rights, except to do it unconstitutionally. I hope you're following that logic. It's very, very important. Government's purpose, according to the Declaration, is to protect unalienable rights, not grant them. So the court ruled that abortion is a political issue. Pay a lot of attention to that, properly addressed by states. And this means some states will ban abortions, some will apply rigorous regulation to abortion, some will choose loose regulations, others will make sure abortions are legal and that their states become destinations. The Democratic Congress may try. The state of Minnesota certainly has tried already. Michigan, Vermont, and California have enshrined abortion into their constitutions already, and I'll explain that in Minnesota, how they claim it's a constitutional right. California wants to be a destination state, as I understand, is building abortion abortuaries, if you want to use that term, abortion clinics, in hoping that lots of people will fly out there to end their pregnancies. Now, as a result of the 2022 election in Minnesota, for those of you not in Minnesota, it's still educational what happened here. Keith Ellison, who won re-election as Minnesota's Attorney General by 0.7 some percent. I mean, he beat my former student Jim Schultz by just a sliver. Minnesota, he said, will be a destination state. And he didn't mean by that the Mall of America, unless, oh boy, I hate to poison your mind on this, but supposing some abortion provider sets up shop in the Mall of America, oh my, I hope they never make that decision. What made it possible is a decision called Doe v. Gomez. And I'm not going into length on this, I'll just tell you about it. 1995, there was a case that went before the Supreme Court of Minnesota that was really about funding of abortions for people on Medicaid. And Minnesota had voted pro-life on funding, refusing to fund Medicaid abortions or any abortions for many decades. And that was DFL and Republican legislators that made that possible. They had a pro-life coalition. And Doe, who turns out to not apparently be a human being, at least they couldn't produce a Doe during the hearings, challenged the health commissioner that they had a right to, not only a right to abortion, but they had a right to having the state pay for them. The Attorney General at that time, Mr. Hubert H. Humphrey III, and the Hennepin County Attorney at the time, Michael Freeman, both stipulated that there was a right to abortion in our Constitution. Folks, read it. There isn't. At least read the version of that day, unless it was added in. So in Minnesota, Doe v. Gomez theoretically established the right to abortion. You will even hear very honest statements by legislators today saying why they have to pass their pro-abortion legislation is because Doe v. Gomez was decided by a court just like Roe v. Wade, which means that a future Minnesota court could overturn Doe v. Gomez and throw it all the way back into the legislature, which is why the legislature is debating it right now. What would it take to change it? What would it take to change this ruling in Minnesota, the election process? Okay. We would have to elect, if you're pro-life, we would have to elect pro-life legislators who would pass pro-life legislation that would be adjudicated in the courts and eventually decided by a pro-life dominated Supreme Court. Right now, it's 5-2, and you can't even be sure of the two, but 5-2 that would probably vote against overturning Doe v. Gomez. And the only way you could change that is to elect pro-life judges, because in Minnesota we elect judges but we're very, very poor at that. We almost always elect the incumbents, or you elect a governor who is pro-life, who, when he gets the chance to appoint a person, I won't go into why that happens, but appoint a person to the Supreme Court, chooses only a pro-life judge. Folks, I'm being honest with you, it's 40 years, but it's worth fighting for. Now, the Supreme Court, I reasoned this from their decision. Well, actually, they did discuss this. They identified 3 different groups on the issue of abortion, that there was a group of folks who have a deeply held moral conviction about the origins of life, that God is creator, and a personal responsibility to protect and advocate for life. Raise your hand. I'll raise mine. That's me. I believe. There's another group that feels, and I do that honestly because I think you have to root your beliefs in well-researched logic. You can't just believe. We believe the Word of God, and we study the Word of God, and we'll change our belief if the Word of God challenges us. Well, if you study the Constitution as it was written, you can believe in those principles, those enumerated powers as they were intended, and then apply your moral convictions to them. Okay, so there's a group that feels they have an emotional investment in keeping abortion legal, even expanding it, and they feel it's a civil right, and it's about controlling their own body. Then there's a third group. The third group are those who think. They're people who think, who reason that life should be protected, and they rationalize the meaning of the law so they don't offend anybody who doesn't agree. You know the type. This is Minnesota nice, right? We wouldn't want to say anything to get anybody riled up. Well, I do. Okay. Or maybe they just don't want to be bothered. And this is the group right here that is identified politically as the voting bloc that we have to appeal to. That's what we're told. Okay. And I think it's true politically, if we were having a political lesson here, that we have to appeal to people who think that's all it is. And we have to get them over to the belief side. But I contend there's another group, and that's us, people who believe that we have a deeply held moral conviction about the origins of life, but we're not engaged. And we have to engage, and we can't assume that other people of faith-based people, rational faith-based, well, maybe I shouldn't put the word rational in there, but I'm saying people who trust the Lord, who trust the Word, people who have a deeply held moral conviction about life, human life. These are people we have to convince to step up to the plate. One of the things that, and I'll say we bemoan it, is when there are pro-life gatherings that are church-based, they're often poorly attended, and maybe it's more discussion than it is action. I know that at our church, they strongly encourage engagement, in the March on Life and so forth, but it's so much more than that. There's a troubling assertion in the decision that I want to go back to just for a minute. And the justices said, given that procuring an abortion is not a fundamental constitutional right. Remember that H.R. 1 and House File 1 and Senate File 1 in Minnesota said it is a fundamental right. They didn't use the word constitutional. They called it a fundamental right. So the pro-abortionists are addressing this issue right here from the Dobbs decision. Given that procuring an abortion is not a fundamental constitutional right, it follows that the states may regulate abortion for legitimate reasons. Oh boy, when you see how this should be turned around, and when such regulations are challenged under the Constitution, courts cannot substitute their social and economic beliefs for the judgment of legislative bodies. Look at this. Abortion is not a fundamental constitutional right, but human life is a fundamental constitutional right. Without human life, none of this matters, right? We wouldn't even be having this discussion because we wouldn't be here, okay? Why didn't they write, given that human life is the single most fundamental of all rights? But that would have really changed the way they came down on their decision. Well, that's the way I come down. Which way do you come down? Is human life a fundamental right? And is it the single most fundamental right? Really? Think about it. So the complete federal right to abortion means that I created this in 2021, that faith communities largely surrender to and accept the idea that preborn human life has no value unless the mother decides otherwise. We've just kind of thrown in the towel, and we've accepted that because, and I would say that because it's not evidenced by any action or large scale action to end it. And religious conservatives give up and they give assent to abortion rights. How? By not teaching about the infinite value of human life and the civic applications of that truth, by staying away from the debate. So what do we do now? First of all, you got to recognize this is going to be a long, tough political process. Dobbs did not end the decision or the discussion by any means. It did just the opposite. And we have to decide personally whether we're going to pursue an absolute position or incrementally change laws. Again, I don't want to get into a political strategy meeting with you. I know this stuff. I know how it works. But there are people, and my dear friend Alan Keyes, I was his campaign manager for president years ago, and we've had this discussion over and over and over. He is a black man. He is the descendant of slaves. He would not entrust his ability to live in liberty and freedom to 50 state legislators deciding the value of black human life. Can I be any more blunt? And so he totally supports the 13th Amendment, which bans slavery, and the actions of our Congresses and the people to try to create equality and give us that sort of way to live. He could never tolerate 50 states deciding their own position on something like slavery. And so he believes very strongly in the absolutist position that we have to have a federal human rights amendment outlawing abortion, establishing the innate right of human life. And I would agree with that, except that political reality is you have to do this incrementally. And so that is happening. Mississippi, I believe, passed an 8-week bill, and I'm not up on this, but there are several states that have passed absolutist bills, that have passed regulatory bills, heartbeat bills, and so forth. Those are all incremental changes that eventually will get themselves heard by a broader population and maybe eventually into the Supreme Court. In that 15 weeks in Dobbs will be reduced to 10 and then to heartbeat. And maybe someday we'll be able to have that debate about an amendment. You also have to organize, recruit, and elect pro-life officials. And then you got to ride herd on them. I am close to many, many elected officials. Their friends or good acquaintances as much as they can be, and they're dedicated to a pro-life position. But boy, tough votes come up, and it's easy to fudge a little bit here and fudge a little bit there and not understand the unintended consequences of those votes. So you have to not only recruit and elect pro-life officials at all levels, talking about well, maybe not the water quality board or the park board, maybe, because they eventually become the others, but your city councils and your county boards and legislators all the way up. And what about our backyard? I got this from Eric Erickson. If you don't know him, he's quite a remarkable thinker, very plain spoken thinker. I'm not saying we shouldn't focus on Washington. I'm not saying it is not important, but I am saying Scripture is pretty clear. We're to seek the welfare of our local community. And so many of us want to impose our view of things on everyone else nationally. We've ignored our local community. So he says, I have this theory that if we all started investing ourselves in the local communities, that we'd improve them. And by improving them, we'd improve our state overall. And if people in other states are doing the same, those states would be improved. And by improving each state, we'd improve the nation. The roots of the nation matter. That's you. We call it the grassroots. So we educate, we persuade, We get educated ourselves so we know what to say. I understand that a witness can only testify to what he or she knows. We pray, we pray, we pray. Now, I got a call from a friend of mine, and I identified him here, Bob Conroy, and I want to give him credit for this. He was going to make a video on our times, and it was based on, he's a former hockey player, by the way, Bob is, and he's from my era. I didn't play hockey, but we all know Herb Brooks if you're from anywhere. But if you're especially from the east side of St. Paul like me and you went to his high school, we know Herb Brooks and the great Miracle on Ice of 1980, and it was made into a movie, Miracle on Ice, and it's incredible. If you haven't watched it, you got to do it. So he gave this speech right at the end, just before the boys went out to play the Russians, and he said, "You were born for this. Great moments are born from great opportunity, and that's why you have what you have here." Then he went on to say about hockey, and I'm saying, no, today, you were born for this great opportunity, this great time, right now, today. And he said about the Russians, we shut them down. Let that sink in. We shut them down. And he said, you were born to be hockey players. But what if those boys had never been born? What if those boys had been aborted? What if your mother had aborted you or me? My mother had. We wouldn't be here having this discussion. That is so profound. And so he went on, he says, but you were born, and I say, but you were born, and this is your time. That's what he said, this is your time. And he ended by saying, and we shut them down. I'd love to hear from you, good, bad, or otherwise. Continue the discussion. At our church, the pro-life committee will certainly delve into these issues. I hope you're doing it wherever you worship. Thank you so much for taking time for this video, and hope that we cross each other's lives again. God bless you. I appreciate you. I love you. And I pray God will bless our country again.